but my name is Clayton Wire. I'm an attorney and a whistleblower advocate. Representing whistleblowers is a large part of my practice, as well as other complex commercial litigation, some civil rights and employment matters. But what I'm really here today is to talk to everyone about not only the national holiday, Whistleblower Appreciation Day, but also some of the history and background of whistleblower statutes in the United States, some of the previous whistleblowers that have made an impact on our country, and then go through some of the incentives and protections that whistleblowers in the United States currently have. You can find out more information about any of this at ilovewhistlblowers.com or whistleblower-attorney.com. Now, I think that there's an initial requirement to any discussion about whistleblowers, and that is really, who is a whistleblower? Now, a whistleblower, I like to think of them as a person of conscience. They're a person who exposes fraudulent, unethical, illegal practices that they notice as part of their everyday life, usually as part of employment. Whistleblowers are persons who have the courage and audacity to put their interests secondary to the interests of society at large. Oftentimes, whistleblowers face severe retaliation. Their activities are often detrimental to both themselves professionally as well as personally. There are lots of stories about whistleblowers who face death threats, actual death, but things like blackballing from an industry are not uncommon for whistleblowers. Whistleblowers are usually tenacious, they're courageous, they're selfless, and oftentimes they're the smartest people in the room. We often refer to them as the sharp pencils, people who keep specific track of information and are there to pose a check on unethical or illegal conduct. But this is obviously from my side of the coin as a whistleblower advocate. This is a two-sided coin. So while whistleblowers, from my perspective, are courageous individuals who expose wrongdoing, oftentimes on the corporate or the other side of the coin, they're seen as that they're engaging in the ultimate breach of betrayal. And so there's the issue of whistleblowing generally is fraught. There's kind of a split oftentimes between large corporations and entrenched government officials, and then the individuals, the little guy who are trying to protect society at large. Now, what we're here to talk about and kind of what sparked this webinar is National Whistleblower Appreciation Day. Now, National Whistleblower Appreciation Day is this Sunday, July 30th. The Senate Whistleblower Protection Caucus has actually already introduced a resolution. A little late this year, they introduced it on Thursday. So they introduced it, or Wednesday, pardon me. So there's only a few days for them to pass it. But the resolution is similar to those in the past. On your screen, you'll see statements from the release regarding the resolution for National Whistleblower Appreciation Day, as well as a quote from Senator Grassley. Senator Grassley is a huge advocate for and friend of whistleblowers. He is kind of the leading voice on the Senate Whistleblower Caucus. And so, much of what they say in this resolution re-emphasizes the importance of whistleblowers in our society. The comment about shining a light on fraud, waste, and abuse. They note in the federal government, but that can really be generalized across private industry as well. I mean, whistleblowers really are people who are exposing things, shining the light of day on illegal conduct in order to stop that conduct. I particularly like Senator Grassley's comment that whistleblowers are patriotic Americans who bring accountability to government, rooting out waste, fraud, and abuse. Again, that is a comment that is very true, but it's also true for private whistleblowers as well, people outside of the government. Now, the National Whistleblower Appreciation Day, what it really is it's the 239th this year anniversary of America's first whistleblower statute. So America's first whistleblower statute, there's somewhat of an interesting backstory to it. In 1777, a couple of naval officers, Samuel Shaw and Richard Marvin, blew the whistle on, exposed, reported the conduct of their commanding officer. In fact, the commander-in-chief of the entire Continental Navy at that point, Commodore Essex Hopkins. Now, Hopkins had engaged in what they saw as torture and abuse of British POWs during the Revolutionary War. As thanks for exposing this horrible conduct, Hopkins and Shaw were dismissed from the Navy, arrested, and Hopkins pressed charges against them for criminal libel. Now, interestingly enough, both Shaw and Marvin appealed to the Continental Congress. Continental Congress got involved, and not only did they dismiss Hopkins from his post, but they passed a resolution to provide defense costs, attorney fees for Shaw and Marvin, and to provide Shaw and Marvin with any documents that they needed regarding Hopkins' conduct. And so you'll see on screen now that original resolution, that America's first whistleblower law. Now, what's so interesting about this law is what it's resolved. You know, the Continental Congress made this broad proclamation before it happened, and it stated that it is the duty of all persons in the service of the United States, as well as all other inhabitants thereof, to give the earliest information to Congress or other proper authority of any misconduct, frauds, or misdemeanors committed by any officers or persons in the service of these states, which may come to their knowledge. That statement is really an embodiment of the reverence that whistleblowers have had in our country since the 18th century, since its founding. And so it's important that we celebrate this. It's important that National Whistleblower Appreciation Day be respected and observed. And it's great that the National Whistleblower Caucus, Whistleblower Protection Caucus, is taking that step to do that. Now, whistleblowers have been around for a long time in our country, and in fact, there are many recent modern examples of whistleblowers. Some of the larger names that people may know of whistleblowers, obviously Edward Snowden comes to mind. Mr. Snowden was a 29-year-old NSA contractor who disclosed information to the media regarding NSA surveillance tactics, particularly surveillance tactics whereby private U.S. citizens' cell phones and other communications were being watched. Snowden's actions were condemned. He ultimately had to flee to Russia, where he has been granted asylum through 2020. As a result of Snowden's actions, the Obama administration and the Congress at that time passed the USA Freedom Act, which actually limited the NSA's ability to cast surveillance on private citizens, and particularly on cell phone communications. The second whistleblower you see on your screen there is Karen Silkwood. Silkwood her life story was the subject of a film bearing her name, but she was essentially a nuclear whistleblower. Again, she was a young woman of 28 when she reported to the media numerous health violations at a Kerr-McGee nuclear power plant that she believed were making her and other workers ill. Unfortunately, she died in a mysterious car accident on her way to give the New York Times reporters, whom she was in communication with, documents regarding the conditions that she had identified. And the third person you see on your screen there, colloquially known as Deep Throat, otherwise known as Mark Felt. Mr. Felt was the individual who provided Bob Woodward and Carl Bernstein of the Washington Post with documents evidencing Nixon's involvement in the Watergate break-in. All three of these individuals have something in common, obviously, and that's their disclosure of information to the media. But whistleblowing generally is much broader than that. Many whistleblowers, in fact, most whistleblowers, are private individuals who report information, report illegal conduct internally within their own organization, or oftentimes to a governmental entity. And so whistleblowers are certainly not limited to those individuals who report to the media, but the larger examples of whistleblowing are usually those types. Now, having defined whistleblowers and having gone through some of the history, going to the legal side of things, there are really two claims that whistleblowers have, and those are either incentive, bounty, or qui tam claims on one hand, or retaliation claims on the other, and we'll go through those. Whistleblower bounty claims. These go by a number of names. Like I said, incentives, bounties, key tam. Key tam has a specific meaning, but sometimes it's used generally in this category. What all of these statutes share is that in exchange for a whistleblower giving the government information about illegal conduct or fraudulent conduct, the whistleblower receives in return a portion of whatever the government is able to recoup. Now, the most commonly used provision is the False Claims Act, and that's really where the term key tam comes from. Key tam is a derivative of a much longer Latin phrase, but essentially means those who stand in the shoes of the king. And in this circumstance, what key tam means is an individual, a private individual, who stands in the shoes of the federal government in order to enforce the federal government's rights under the False Claims Act. This is a unique provision. There are only a few statutes that have it, but the False Claims Act is far and away the most widely used. These individuals who stand in the shoes of the federal government are known as relators. A relator is someone who essentially prosecutes the claim on behalf of the federal government. But there are strict and important limitations on how a relator can prosecute those claims and what they must do in order to be entitled to any sort of recovery or bounty. The False Claims Act itself is a very strong statute. The potential damages under it are treble damages for the government, including per claim penalties. What this essentially means is that an individual can bring a claim and the damages don't necessarily have to be that high, because if they're successful, that amount can be tripled. And then if you're dealing with a situation where there are many false claims submitted, then there can be a per claim penalty. Now, it's important to note that this particular statute does not apply to tax fraud. There's a separate whistleblowing provision for tax fraud, but False Claims Act key tam lawsuits cannot be based on tax fraud. Another important notation is the statute of limitations. There is a 6-year basic statute of limitations from the violation that's being reported, or a 3-year statute of limitations from the time that the government is put on inquiry notice regarding any violation that's being reported. Now, the important piece here is the logistics of filing a key tam action. So a key tam action must be filed under seal with the clerk of the district court in which the violation occurred. And oftentimes we're dealing with national operations, companies who are across many different states. But this seal requirement is very important because if it's not filed under seal, then the relator loses all entitlement to award under the lawsuit. This is not just a normal seal either. It's not just the clicking of a box on a electronic submission form. It must physically be filed under seal with the clerk. Now, in addition to filing under seal, what the relator also must do is provide the U.S. Attorney's Office, and in the case of state False Claims Act claim, which we'll talk about a little bit later, the State Attorney General, with a separate memorandum in addition to the complaint. The memorandum has to include all of the important information that the whistleblower, the relator, has accumulated regarding the violation that they're bringing the lawsuit regarding. Essentially, what you're trying to do is give the case to the government on a silver platter. At that point, the government has an opportunity to investigate the claim, to review the information that the whistleblower has submitted, and eventually make a determination whether or not it will intervene on the claim on behalf of the federal government. Now, there are some important prerequisites in order for a relator to file an adequate lawsuit, and remember, it has to be filed under seal. The first prerequisite is that you must be the first to file. In other words, a relator has to be the first person to file a key tam lawsuit on a particular type of violation. So anyone who comes subsequent is either in line or their claim is dismissed because it's so similar to a prior key tam lawsuit. Another limitation is the public disclosure bar. What this does is it precludes any key tam lawsuit that's based upon the public disclosure of information. if the information in the lawsuit is substantially similar to allegations that were publicly disclosed in a prior lawsuit, in a prior government communication, and in a number of different mediums, then the entire lawsuit is precluded. There is an exception to this, and it's an important exception, and it's called the original source exception. Under this exception, a relator may still bring a claim if they are the original source of information that was publicly disclosed. Now, the relator's award is an important piece of the False Claims Act. Generally, the relator's award ranges between 10 and 30%. The 30% threshold, the highest award possible, is 30% of any amounts that the government or the relator is able to recover as a result of the QTAM lawsuit. And that 30% is only available if the government chooses not to intervene and the relator in turn chooses to still pursue the lawsuit on behalf of the United States. So it's important to realize, though, that the relator is not entitled to all of the money that's recovered. Let's say the relator recovers $100 in a QTAM lawsuit. In the best case scenario, the relator will only receive $30 of that $100. The awards to a whistleblower go down from there. The award generally, when the government does intervene, is between 15 and 25% of the recovery. There are also other levels of recovery on award in situations in which the relator is involved in the fraud that they've reported and filed a lawsuit regarding, if they've been criminally indicted regarding that conduct. There's also a risk involved if the relator continues to pursue a QTAM lawsuit after the government chooses not to intervene. There have been several cases in which defendants have actually recovered attorney fees and costs against a relator when they're successful in such a lawsuit. Now, I've mentioned this previously, but most states have a state False Claims Act. Many states' False Claims Act is just as broad as the federal False Claims Act. In other words, it covers any situation in which a company or individual, hold on real quick, I'm just going to make sure we're all muted here. It covers essentially any situation in which an individual either obtains payment from the federal government because of fraud or avoids payment to the federal government on the basis of fraud or a false claim. There are also other situations in which the False Claims Act covers situations where a contractor, for instance, is not the one who submits the claim directly to the government, but they cause a false claim to be submitted. Now, state False Claims Acts are oftentimes narrower. In particular, Colorado's is limited to only Medicaid claims. In other words, only fraudulent Medicaid claims or fraudulent billing by Medicaid providers are covered underneath Colorado statute. Colorado is somewhat of an anomaly, though, and so many other state provisions apply much more broadly. The other main bounty provision for whistleblowers is the Dodd Frank Act. The Dodd Frank Act was passed in response to many of the actions, the shenanigans that caused the 2008 global recession. So the Dodd Frank Act has a specific bounty provision. This specific bounty provision allows a whistleblower to recover between 10 and 30% of whatever the government is able to recover when they disclose information directly to the SEC that results in a successful prosecution. Now, there are limits on this. The prosecution has to lead to a recovery of monetary sanctions in excess of $1 million. So if the SEC's prosecution only results in $750,000 or $600,000 in recovery, then unfortunately the whistleblower is not statutorily entitled to recovery. There may be some situations in which the SEC will make an exception, but under the statute, that's not the case. The SEC bounty process is far and away different from the False Claims Act process. It's much more of an administrative process. Initially, An SEC whistleblower under the Dodd Frank provision is required to report their information and disclose everything they have to the SEC via a specific tips, complaints, and referrals, or TCR form that's available online. Once that form is submitted to the SEC then will either choose to investigate or not. If it does investigate, sometimes the whistleblower would be called as a witness or to help provide additional information. Once the SEC goes through its investigative process and eventually prosecutes a claim, once there is a favorable recovery that's obtained, there is a notice of covered action that's published by the SEC regarding that particular matter that was initiated because of a whistleblower disclosure. And then the whistleblower must again submit another form to request their portion of that recovery, and they have to do so within 60 days. Unfortunately, there are no appellate rights outside of the SEC for bounty awards. Essentially, what the SEC determines is the end-all, be-all. You can ask for review within the SEC, but it's essentially up to them. One important piece of the Dodd-Frank whistleblower bounty provision is that the whistleblower can remain anonymous. This is incredibly important to whistleblowers because, as we discussed, whistleblowers often face severe retaliation. And so if you're a current employee and you have information regarding some sort of securities fraud or inappropriate securities conduct by your employer, you can report that and still remain anonymous, which is very, very helpful. In order to remain anonymous, though, the whistleblower must submit their information regarding the matter via an attorney. So the attorney essentially submits the report, the TCR report or TCR form, and then the attorney is the one who collects on behalf of their client any award that occurs. There's a similar process for the Commodity Futures Trading Commission as well, but the securities provision under Dodd-Frank is the most commonly used and has resulted in the most whistleblower awards to date. The next bounty provision is the IRS Whistleblower Program. The IRS program is unique. Essentially, it allows for a whistleblower to collect up to 30% of whatever the IRS is able to recover, including taxes, penalties, and other amounts collected, because of information that the whistleblower submits to the IRS. Now, there's two different levels of whistleblowing and two different levels of award. The first is if the whistleblower discloses information that results in tax collection in excess of $2 million. In that situation, the whistleblower is entitled to between 15 and 30% of whatever the IRS recovers. One note on this, if the tax violations are involving an individual, that individual's annual income must be in excess of $200,000 in order for the whistleblower to be entitled to an award. An appeal of an award can be made to tax court under that particular provision. There's also a secondary provision for those disclosures by whistleblowers that result in a recovery of less than $2 million. In those circumstances, the award by the IRS is essentially discretionary. The maximum amount that a whistleblower can receive under that discretionary provision is 15% of whatever is recovered. There is no appellate rights or right to appeal of those awards, unfortunately. Now, the procedure for the IRS whistleblower statute is a little bit different as well. Essentially, it's a black box submission. The whistleblower puts together their information, submits it to the IRS, and they wait. And they wait some more. The IRS doesn't inform them of the existence of a prosecution, doesn't usually and oftentimes does not contact the whistleblower again, although there are some exceptions to that. The IRS essentially takes care of the entire case, and the whistleblower has no idea what's going on. In fact, in cases that I've had where I've tried to get information from the IRS about what's going on, the IRS simply refuses. One important thing to note under the IRS whistleblower provision is that there is no anti-retaliation provision as of yet. There have been bills introduced to add it, but what this means is that someone who discloses information to the IRS regarding a tax violation may legally be retaliated against for such disclosure. And so it's important to know that, because while the False Claims Act and DoddFrank Act both have anti-retaliation provisions, an IRS whistleblower is not provided the same. Now, we talked about the two different types of claims. We've covered the three main types of bounty, QTAM, or incentive type claims that a whistleblower can bring. The next claim is a retaliation claim. Retaliation claims are very important. What this provides is protection for individuals who want to become a whistleblower or who have already blown the whistle from retaliatory conduct by their employers, by the government, and by other individuals who would seek to do them harm because of their whistleblowing activities, because of their protected activities. Now, we'll talk about the three main types of whistleblower retaliation claims under federal law, under the False Claims Act, the Dodd Frank Act, and Sarbanes-Oxley Act. False Claims Act retaliation provision is a very strong anti-retaliation provision, and it was actually recently strengthened quite a bit. It actually covers and protects individuals who either take steps towards filing a QTAM action or efforts to stop one or more violations of the False Claims Act. And that second piece is very important and was only recently added to the anti-retaliation provision. What it essentially does is there were a lot of court decisions that required the plaintiff in a False Claims Act anti-retaliation case to show that they were taking steps towards eventually filing a QTAM claim, or had in fact already filed a QTAM claim. And so they limited the protected activities so much that even individuals who were trying to internally stop a violation of the False Claims Act were not protected. Recent amendments have actually changed that. And so now there is a much broader category of protected activity, which is very important. What this means is that oftentimes internal reporting of reasonable suspicion of a violation of the False Claims Act, whether or not it uses the specific language of the False Claims Act or fraud, will oftentimes be protected. This often occurs in medical services situations where an individual, a billing agent or a nurse or a doctor, reports conduct that they believe violates a certain predicate or requirement to payment under Medicare or Medicaid. In those situations, that's protected activity. In other words, that individual should not be retaliated against for engaging in that kind of conduct. Now, if a whistleblower is retaliated against for engaging in protected activity, they're entitled to bring a lawsuit to seek damages for that retaliation. The False Claims Act actually has a really broad damages provision and a very unique damages provision. In fact, if a whistleblower is retaliated against for either taking steps in furtherance of a QTAM action or efforts to stop one or more violations of the False Claims Act, they're entitled to 2 times the amount of back pay, interest on the back pay, and compensation for any special damages sustained, including attorney fees and costs. Now, that 2 times back pay is very important. We'll see it again under the Dodd Frank Act, but it allows a whistleblower who may not be the most highly compensated individual in the company to still have a good damages claim and still have a good case to move forward on, and really provide both an incentive for the whistleblower to protect their rights as well as a disincentive for the company to engage in retaliatory conduct. There is now a 3-year statute of limitations on False Claims Act retaliation claims. What this essentially means is that a whistleblower must bring their retaliation claim within 3 years of the retaliatory act, usually 3 years of their termination. There is no, and we'll talk about this a little bit in regards to Sarbanes-Oxley Act and some other whistleblower statutes, but there is no administrative exhaustion requirement for a False Claims Act retaliation claim. A whistleblower can go directly to federal court to enforce their rights. Now, there are other anti-retaliation statutes. Another one that we've talked about and that I've referred to is the Dodd Frank Act. Again, the Dodd Frank Act, enacted in the wake of the 2008 financial crisis to address some of the issues that occurred there, has pretty broad protected activity. It protects individuals who engage in reporting information to the SEC, participation in SEC investigation, engaging in protected activities under the Sarbanes-Oxley Act, engaging in required or protected activity under the Securities Exchange Act, and reporting possible commission of a federal offense to law enforcement, and making required or protected disclosures under any rule administered by the SEC. That last piece is important because it has been held to cover disclosures of violations of the Foreign Corrupt Practices Act. The Foreign Corrupt Practices Act is essentially a statute that precludes U.S. companies from engaging in bribery and other improper conduct overseas to win contracts and exert influence. This is a large concern for many multinational U.S. companies and is oftentimes one of the protected activities that is most litigated under the Dodd-Frank's anti-retaliation claim. The procedure for Dodd-Frank's anti-retaliation claim does not require administrative exhaustion. In other words, you don't need to submit your claim to an administrative authority. You can go directly to federal court. However, those claims must be submitted within 3 years of the retaliation. The remedies under the Dodd Frank Act, similar to the False Claims Act, are very whistleblower friendly, including, again, 2 times of the amount of back pay. There's also a provision for reinstatement into the whistleblower's prior position. What that means is that the individual can actually go back into the company where they've blown the whistle, which is oftentimes a very difficult proposition for a whistleblower. So what courts will often do instead of reinstatement is provide some sort of front pay, some sort of compensation to the whistleblower for pay that they're going to miss out on in the future because of the illegal retaliatory conduct. There are also provisions for compensation for attorney fees, expenses, things like that. Now, an important note about the Dodd-Frank Act is the current split of authority that exists regarding the definition of a whistleblower under the retaliation provision. Now, one set of courts have declared that a whistleblower, in order to meet the term whistleblower and be protected under the Dodd-Frank Act, an individual must disclose information to the SEC. While a second set of courts, and a few different courts, have held that an individual does not have to disclose information in order to be to the SEC in order to be protected by the Dodd-Frank Act's anti-retaliation provision. Now, obviously, for our purposes, for my purposes, the second set of courts' interpretation is the most whistleblower-friendly of the two. And the reason for that is because the second interpretation allows individuals who internally report violations of the Securities and Exchange Act, violations of federal law, violations of any rule administered by the SEC. If they internally report those things, they're still protected. Now, there is currently a case at the Supreme Court, or was accepted by certiorari to the Supreme Court, called Digital Realty Trust v. Summers out of the Ninth Circuit. So the Supreme Court is going to resolve this split in authority and is going to resolve whether or not internal whistleblowers are protected from retaliation or whether the Dodd-Frank Act only protects individuals who report information to the SEC. So we'll be watching that intently. The last major statute that we'll talk about a few others, but the last major statute I wanted to touch on is the Sarbanes-Oxley Act. The Sarbanes-Oxley Act is kind of one of the quintessential whistleblower protection statutes of the current 21st century. It is probably one of the most used anti-retaliation provisions for whistleblowers. It is probably one of the most whistleblower-friendly statutes out there as well. So the Sarbanes-Oxley Act protects individuals from retaliation by publicly traded companies or any contractor or agent of such company. So it precludes those individuals from retaliating against whistleblowers for reporting what they reasonably believe to be mail fraud, wire fraud, bank fraud, securities fraud, or a violation of any rule or regulation of the SEC, or a violation of any provision of federal law relating to fraud against shareholders. Again, similar to the Dodd Frank Act, but actually much more narrowly, the Sarbanes-Oxley Act is really geared towards whistleblowers who report securities violations. But it goes a little bit broader than that by including mail fraud, wire fraud, and bank fraud. So while Sarbanes-Oxley may have been targeted to a specific set of securities fraud issues, it certainly can be used in other circumstances. Now, the scope of defendants is really important under the Sarbanes-Oxley Act because it actually does provide for individual liability for officers and directors and agents of publicly traded companies, meaning that, and this has happened in multiple occasions, claims can be brought against people like the CEO of a publicly traded company for engaging in retaliatory conduct against a whistleblower. In fact, the Supreme Court recently held that a public company's private contractors are covered under the whistleblower protections of the Sarbanes-Oxley Act, meaning that somebody like an attorney or an accounting firm or any other private contractor of a publicly held company who engages in retaliatory conduct for a whistleblower engaging in one of the forms of protected activity, you know, reporting mail fraud, wire fraud, bank fraud, those sorts of things, they are also covered by this act, and they can also be subjected to liability. Now, the scope of protected activity under the Sarbanes-Oxley Act, we've talked about a little bit, but it's important to note that the Administrative Review Board, which is the administrative appellate agency that administers the implementation and the cases that fall under the Sarbanes-Oxley Act, has held that a whistleblower need only have a reasonable belief as to the potential violation of one of the listed statutes or rules. In other words, there doesn't have to be an actual violation for a whistleblower to be protected. It's sufficient for them to have a reasonable belief that one has occurred, is occurring, or will likely occur in the future. Now, the Sarbanes-Oxley Act also has a unique burden-shifting process. Essentially, it's a very whistleblower-friendly process, and that's on purpose. Congress specifically implemented a whistleblower-friendly and defendant and difficult for defendants process in order to encourage whistleblowers to come forward. Under this provision, all the whistleblower needs to do is establish that they engaged in protected activity, that the defendant knew of their protected activity, and that they suffered some adverse action because of their protected activity. Now, the because of there is important because what the statute requires is that the protected activity be a contributing factor in the adverse action taken. And we'll get to that in a second. But it's only after the whistleblower establishes that the employer can come back and assert an affirmative defense that they would have taken the same adverse action even in the absence of the protected activity. But the employer or the defendant has to prove that affirmative defense by clear and convincing evidence, which is a much higher burden than the simple preponderance of the evidence standard that the whistleblower must meet. So it's a very whistleblower-friendly provision, and it's one we like to see. Now, the causation component that I just mentioned, this contributing factor test, is one of the reasons why this is such a whistleblower-friendly statute. What the contributing factor test really says is that if protected activity played any role whatsoever in the adverse action, that adverse action is a violation of the Sarbanes-Oxley Act. That can mean that an employer has 5, 10, 15, 20 reasons for terminating or taking some sort of adverse action against an employee. But if one of those reasons is protected activity, if one of those reasons is that the person disclosed information regarding a violation of an SEC regulation or rule, or disclosed information regarding what they reasonably believe to be wire fraud, then that violates the Sarbanes-Oxley Act. It doesn't have to be the sole reason or the motivating factor. It just has to be a reason for the adverse action. The remedies under Sarbanes-Oxley statute, unfortunately, are not nearly as protective and beneficial as either the False Claims Act or the Dodd Frank Act. Essentially, a whistleblower is entitled to reinstatement and potentially front pay. They're entitled to back pay with interest and recovery of their attorney fees. Now, a very important thing to note about the Sarbanes-Oxley Act is that it does have an administrative exhaustion requirement. And what that means is that a whistleblower who wants to assert a Sarbanes-Oxley whistleblower claim for retaliation must submit a complaint or charge to OSHA, to the Occupational Safety and Health Administration, within 180 days, a very short time frame, of the retaliatory act. So that's a prerequisite to ever bringing a lawsuit for a retaliation claim. It's only after the whistleblower submits that administrative claim that OSHA begins to investigate, issues a report of its own, and then eventually, if the whistleblower wishes to remain in the administrative context, in the administrative process, the whistleblower can appeal or take their claim onto an administrative law judge, which is essentially a trial court for these claims. And that administrative law judge's decision can be appealed to the Administrative Review Board for internal or administrative appellate review. And then the Administrative Review Board decision can then be appealed to the Circuit Court, the U.S. Federal Circuit Court at issue. But there is also another provision that allows a whistleblower under the Sarbanes-Oxley Act to pull their charge back after 210 days of it sitting at OSHA and directly file that claim in federal court. Now, with recent resource allocations outside of OSHA, OSHA is very behind right now, meaning that a whistleblower who relies on the administrative process is often waiting many, many years for any sort of reward, award, or resolution. And so oftentimes whistleblowers will opt to pull their charge out and directly file in federal court in order to move the process forward. Now, let's talk briefly about some of the other statutes that OSHA and the Department of Labor administer as far as anti-retaliation statutes for whistleblowers. Now, OSHA administers 22 separate statutes that cover things like environmental protections, transportation, consumer protections. There are statutes that cover the federal railroad workers. There are statutes that cover long-haul truck drivers. There are statutes that cover people working in the nuclear energy industry. All of these statutes are administered by OSHA, and all of them require administrative exhaustion, which means that similar to Sarbanes-Oxley Act, which is also administered by OSHA, there has to be a charge that's filed within a very short time frame with OSHA in order to bring a retaliation claim in federal court. Several statutes similar to the Sarbanes-Oxley Act have kick-out provisions whereby that charge can be pulled out and taken directly to federal court. Now, the next group of whistleblowers that I want to talk about are government employees. Government employees have many protections, both state and federal government employees. Now, in Colorado, which is where I'm based, Colorado public employees have protections for disclosing information about many different things, including waste, fraud, abuse by a governmental entity. That's similar to the federal statute, the Whistleblower Protection Act, which similarly protects whistleblowers who disclose information regarding waste, fraud, and abuse. Now, another important protection for whistleblowers, particularly only government employees or employees of public entities, is First Amendment retaliation claims. Now, the First Amendment, like we're all familiar with, entitles individuals to both engage in free speech as well as petition their government for redress of grievances. Now, employees of public entities can file a claim under Section 1983, which is the mechanism for enforcing constitutional rights, when they have been retaliated against for engaging in conduct protected by the First Amendment. Oftentimes, this results when an employee speaks out on an issue in the media or otherwise and is terminated for doing so. Now, in order to be protected, the information that's disclosed, the whistleblower's conduct, must relate to matters of public concern. In other words, it can't relate to a purely personal matter, a purely individual matter. It has to relate to something broader and more of a societal issue. But that statute provides very good protections for what I would classify as whistleblowers, as well as broad remedial measures, including no cap on damages under the Section 1983 statute. There are many state statutory claims as well, including things like what we colloquially call the Smokers' Rights Statute or the Smokers' Law. Essentially, the Smokers' Rights Statute says that an employee cannot be terminated for engaging in lawful conduct outside of work. Now, being in Colorado, I have to mention that the Colorado Supreme Court has held that conduct that is only permitted by state law but is made illegal by federal law is not lawful conduct under the statute. And in that decision, what they found was that an individual who possessed a medical marijuana card and tested positive and was thus terminated from their employment was not entitled to protection under the statute, even though his conduct was lawful under state law, because it was still unlawful under federal law. There are protections for healthcare workers and physicians who report patient safety and care issues. There are protections for state agency contractors who report issues with, again, fraud, waste, abuse, those sorts of things. And there are innumerable other protections. Most states have similar protections, but Colorado, since that's where I'm at, is the examples I was using. Now, another protection for whistleblowers from retaliation is what's commonly known as the wrongful discharge in violation of public policy tort. Now, what this really is an exception to the at-will employment doctrine. Under the at-will employment doctrine, individuals who are employed by a company can be terminated for any or no reason. There are a few exceptions to that rule, one of which is the wrongful discharge in violation of public policy tort. Under this tort, a whistleblower who discloses information regarding the violation of a clear public policy or refuses to engage in conduct that would violate a clear public policy or takes action that is required by a clear public policy is protected from retaliation. The vast majority of states, especially those states without an independent whistleblower anti-retaliation statute, have this tort and have this common law protection for whistleblowers. The key to proving these claims, though, is finding a sufficiently clear public policy that covers the actions of the whistleblower. For instance, things like constitutional amendments, statutory provisions, criminal laws, in some cases, professional codes of conduct, such as professional codes of conduct for CPAs, for attorneys. Also professional duties, such as the fiduciary duties that a real estate agent would owe to their principal, to the person that they're representing. All of those have been held to be sufficiently clear statements of public policy. The problem is that other statements of public policy that are not sufficiently clear, such as private ethical rules that are adopted by organizations like nursing associations, they may not rise to that same level. Another significant protection for whistleblowers, for individuals who disclose improper illegal conduct, are the general anti-discrimination acts, both under federal and state law. So as a general principle, statutes like Title VII, the Americans with Disabilities Act, all of those statutes have anti-retaliation provisions, or provisions that protect individuals who attempt to exercise their rights under those statutes or who report violations of those statutes, and protect those individuals from retaliation. All of these anti-discrimination statutes, however, have an administrative exhaustion requirement similar to the Sarbanes-Oxley Act. However, different agencies. Under federal law, an individual generally has to file their charge within 300 days of the retaliation, and that 300-day limit is only if the state you're in has a state anti-discrimination agency as well. In Colorado, the Colorado Civil Rights Division is our state entity, and if you're going to submit a claim under the Colorado anti-discrimination statute, you have to submit that claim within 180 days. And again, that is a prerequisite to ever filing a lawsuit in federal or state court. The whistleblower, the person who is retaliated against, must file that. Now, having gone over some of the more important whistleblower claims, I think it's important that we talk about a common issue that comes up in whistleblower cases, and that is the retention of documents. Like I discussed earlier, whistleblowers are often the smartest person in the room. They're often the sharpest pencil in the room. But what that means is that they're also the people who are often inclined to build their case, to collect evidence in order to prove their claims or to show their boss that, hey, I've got evidence of this illegal or unlawful conduct. Here it is. But by collecting those documents, a whistleblower may be putting themselves in jeopardy. So it's important that a whistleblower understand their protection, because protections for collecting documents and retaining documents after, say, being terminated can be very different depending on the statute, depending on the scope of documents that you collect, and depending upon how you obtain those documents. There are statutes like the False Claims Act and the Dodd Frank Act that arguably, and in some cases this has specifically been held, protect individuals who are collecting information to bring a key tam, in the case of the False Claims Act, or a bounty claim in the case of the Dodd Frank Act, regarding their employers or other individuals' unlawful conduct. So it actually may be protected activity under those statutes. Unfortunately, statutes like the Sarbanes-Oxley Act, Title VII, things like that, don't necessarily contain those same provisions. So a whistleblower or a would-be whistleblower has to be vigilant and protective about what they're doing. A whistleblower should never go beyond the scope of their employment to collect documents. In other words, there have been cases where a whistleblower has downloaded the company's entire server or hacked into their boss's email account. Those are situations in conduct that could result in not only dismissal of a potential whistleblower bounty claim or retaliation claim, but could also result in the whistleblower being sued themselves or result in an affirmative defense succeeding against the whistleblower. So it's always important that whistleblowers who are contemplating collecting documents and blowing the whistle either internally or externally on unlawful conduct really take a look at the information they have, how they've obtained it, and how they're going to use it. That said, we've really covered a lot here in about an hour. And so I'm going to go ahead and end the presentation and open it up to any questions. If you have any questions, please feel free to type them in the chat function, or I will unmute people, and we'll go from there and see if anybody has any questions. But thank you for joining me. All right. Not seeing any questions, but thank you guys so much for joining me. I very much appreciate it. Please celebrate Whistleblower Appreciation Day and use the hashtag #ILoveWhistleblowers, and keep astride of the National Whistleblower Appreciation Day resolution that was recently introduced, because it would be great if the federal government could recognize it. But other than that, have a great day, and thanks for joining me.